a lecture for my professional responsibility class on Model Rule 4.3. Model Rule 4.3, dealing with an unrepresented person. Here's our rule. Please note that there's no A, B, or C section. This is a nice short rule that's pretty straightforward. In dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. And when the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. The lawyer shall not give legal advice to an unrepresented person other than the advice to secure counsel if the lawyer knows or reasonably knows that the interests of such a person are or have a reasonable possibility of being in conflict with the interests of the client. And okay, so let's talk about this. We kind of have two halves of one rule here. The first is, to go back for a moment, don't mislead an unrepresented person into thinking that maybe you are looking out for them and you're sort of their lawyer too, even though that you're not officially representing them or something. So I know we have a double negative here. Don't imply that you're not, that you are disinterested. And what we mean is, don't imply that you're on their side, even a little, if you're representing a client. Now, what does this not apply to? If this is you talking to people and it has nothing to do with representing one of your clients. And so if you're getting your hair cut and your barber or hairdresser says, oh, wow, you're a lawyer, can I ask you a question? And starts in, now I am going to encourage you when you're or tell you when you are working, it's very likely your employer is not going to be very excited at all about you going around giving free legal advice to waiters and waitresses and flight attendants and people that are cutting your hair or your trainer at the gym and so forth. Why? Because it could come back as a malpractice action. But be that as it may, if you have somebody who wants to ask you for advice about their case and it has nothing to do with you, or they want to talk about a case that that's making headlines in the news, you can talk to them, right? And so you can talk to an unrepresented person, and you can talk to pro ses and kind of coach them a little bit and say, oh, you need to go to this government office and get this form and fill it out, and all of that is fine. Just don't make it sound like, and by the way, I'm here for you and I'm looking out for you, or give the impression that you, I'm sorry, you can go ahead and say, come back and ask me questions. If it's about a client, you can't say, by the way, I'm here for you, I'm looking out for you, or follow up with me, or just check in on you to make sure you're okay, or things like that. If you're representing a client, be very careful about this. And then you actually have an affirmative duty to remind people you're not their lawyer. If there's some reason that if they're starting to talk to you like you are, and also, if you can see coming down the pike that this person's interests are potentially adverse to one of your own clients, in other words, like your client, you happen to know your client is planning on suing this person or vice versa, then you should be very careful not to give them legal advice. And I hope that makes sense. That would seem manipulative. And so now I'm going to go away from the slide and just talk at the camera for a moment and tell you about a case. And I mentioned this case earlier in the semester. This is where the lawyers on both sides did something wrong. And this is the tragic story about the Coca-Cola truck driver who he was intoxicated while abusing substances while he was driving, and collided with a school bus full of school kids and sent that school bus flying off of a high overpass over a ravine, and many of the kids died and the others were very seriously injured, and this made national news and so forth. And I brought this up earlier because the plaintiff's lawyers got some attention after the case, because the Coca-Cola thought this was realized about a week after a few days of nonstop news coverage that this was a public relations nightmare, and offered to settle the case for millions and millions and millions, tens of millions of dollars. And so the plaintiffs' lawyers, who were representing the families of the kids, hadn't really done any work on the case yet, and got a huge contingent fee. But here we're talking about Coca-Cola's lawyers. And so the bus driver who hit these kids down in, I can't remember the small town, but it's kind of by McAllen, Texas, in the South Texas. The bus driver was injured and was hospitalized, but didn't die. And lawyers for his employer, for Coca-Cola, visited him in his hospital room and asked him how he was doing, and then asked for it got him to talk about his version of what had happened. And the bus driver knew that they were Coca-Cola's lawyers, his employer's lawyers, and made some incriminating basically admitted to them that he had been intoxicated while he was driving the school bus, and therefore was not only at fault, but clearly violating company rules and acting outside the scope of his employment. And so here's the problem. The lawyers for Coke didn't explain to this unsophisticated truck driver that they were not his lawyers. And it was kind of reasonable. They should have realized that he would assume that his employer's lawyers would also be his lawyers, or would be looking out for him. And so think about what happens, right? They never tell him, by the way, stop talking to us, because we're not your lawyer, we're Coca-Cola's lawyers, we're your employer's lawyers. So they let him go ahead and make these statements. And now they're going to have kind of essentially a duty to their own client, which is the corporation, to go back and tell management everything he said, and basically because they can get out of liability now by blaming him for everything. And basically there's no respondeat superior if he's acting outside the scope of his employment, and so forth. So these lawyers, they now have a duty to use his statement to the advantage of the company to get out of liability. So this action on behalf of Coca-Cola's lawyers also got some negative attention, as you might imagine. Let's talk about the comments. The rule distinguishes between situations involving unrepresented persons whose interests may be adverse to those of the lawyer's client, and those in which the person's interests are not in conflict with the client's. In the former situation, the possibility that the lawyer will compromise the unrepresented person's interests is so great that the rule prohibits the giving of any advice except to tell the person to obtain counsel. And so you're representing a landlord, let's say, and one of the tenants comes and sees you and stops you in the parking lot one day and says, I have a question about my lease, or something like that. Well, stop right there. You need to say, for your information, I'm not your lawyer, I'm representing your landlord. And really, since it's so foreseeable that there are going to be legal disputes between landlords and tenants, like over unpaid rent or evictions or repairs, health code violations and so forth, probably in that situation, you should say, you know what, you really need to talk to your own lawyer if it's anything about the building at all, right? And now, if they're stopping you in the parking lot because they want to talk to you, get your opinion about the latest, Supreme Court nominee, and that controversy, or a controversy over some celebrity case, or celebrity homicide or something, or something they watched on Chicago PD the night before, that's fine. You can talk to them about that. But if they said, I have a question about my lease, or I have some concerns about my landlord, then you should stop them right there, because you represent the landlord and you don't represent them. And it sounds like this could be an adverse interest, right? Conversely, Conversely, you're getting in your car one day and somebody walks up to you and you don't represent their landlord, and they're getting in the car next to you at the supermarket. And they say, hey, wait, you're a lawyer, right? Can I ask you a question about a quick question about a problem I'm having with my landlord? Go ahead and give them all the advice you want, right? And be careful. You could be creating a client-lawyer relationship if it's reasonable for them to rely on you, and so forth. So watch out for that. But this rule doesn't really say that you have to explain to them, by the way, I'm not your lawyer. Whether a lawyer is giving impermissible advice may depend on the experience and sophistication of the unrepresented person, as well as the setting in which the behavior and comments occur. This rule does not prohibit a lawyer from negotiating the terms of a transaction or settling the dispute with an unrepresented person. And that's sort of two ideas. Number one, if you're talking to someone who's our most sophisticated and experienced person, another lawyer, right? So you're talking to another lawyer, we're almost always going to assume they know that you're not their lawyer, right? And so if they're general counsel at a corporation, they work for another firm or something like that, they know the game. If this is somebody, a business manager who deals with lawyers all the time, every day, they're pretty sophisticated. If this is, on the other hand, a person who is very unsophisticated or uneducated and rarely interacts with lawyers, and that's why they're seizing this occasion to pump you for legal advice, to be their free lawyer, you need to be more careful and explain, by the way, I'm not representing you. And so now, what do you do when you're representing a client and the other party is pro se? This can happen. So this happened to me a few times when I was at legal aid and I was representing tenants, right? So I'm the lawyer for the tenant, and the landlord actually didn't have a lawyer. The landlord is also pro se. So can you talk to the other party if they're pro se? And the answer is yes, you have to, obviously. So in that case, you have to deal directly with the other party, and you may need to negotiate the terms of a transaction or negotiate the terms of a settlement. And then as long as you have explained in that situation, you do understand, I'm not your lawyer, you could even explain, here's what these settlement terms mean. And so let's say the pro se on the other side has never heard the phrase binding arbitration before, and that's in the document that you're drafting, or there's a venue or forum selection clause or something like that. You are allowed to inform the other person of what your understanding that it is. You're allowed to print up the contract or the settlement agreement that the other person is going to sign, explain your own meaning of it, but go ahead and say, my view is this. And I would encourage you as your professor to advise the person to get their own lawyer and to remind them that you are not their lawyer, you're representing the person who's the other party from them. But be that as it may, if you have a pro se on the other side of a transaction or litigation, you have to deal with the situation. You have to interact with them. You can't, right, and finish the deal or finish the case. Okay, if you need to document that you watched this lecture for attendance purposes, our lecture attendance password is susceptible.